Thought I did.
I don't know if I had it. Like there were a
That's
couple of
what
those.
you
Yeah,
said.
there's a lot of support for it.
I haven't seen her. She was in committee earlier, yes.
Passes through some people very quickly.
I'm planning on having her come in at 1,
Oh,
on a bill.
Senate will please come to order. Today's devotional exercises will be conducted by Reverend Rick Swanson, who you're familiar with, of the St. John's in the Mountains Episcopal Church of Stowe. Welcome, Reverend.
I invite you all to stand as you are able. Let us pray. Creator of land, sky, and sea, the one who made heaven and earth, you made us in your image to live as a reflection of your love. Give this Senate of the state of Vermont your vision for the people who have elected them to take action for the common good. May respect and forbearance be their guide. May dignity and hope shape their words written and spoken, and may love be their rear guard. We raise this, our hope and vision to you, the one of all creation. Amen.
Are there any announcements? Seeing none, we have 3 bills for referral under Rule 31. The first being S310. 310 appearing on the calendar for notice affecting the revenues of the state will be referred to Committee on Finance. The second being S120. S120 affecting the expenditures of the state will be referred to the Committee on Appropriations. And S184, also affecting the expenditures of the state, will be referred to the Committee on Appropriations. We do have a committee bill for introduction, S312. It is introduced by the Committee on Institutions. Please listen to the first reading of the bill.
S312, an act relating to the Salisbury Fish Hatchery.
Now you've heard the first reading of the bill, and being a committee bill will be placed on the calendar for notice. We have one House bill for reference, being H766. It passed the House on March 13th. Please listen to the first reading of the bill.
H766, an act relating to prior authorization and step therapy requirements, health insurance claims, and provider contracts.
Now you've heard the first reading of the bill is referred to Committee on Health and Welfare. That brings us to the orders of the day. We have up for consideration S197. S197, third reading was ordered for S197. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
S197, an act relating to the procurement and distribution of products containing perfluoroalkyl and polyfluoroalkyl substances and monitoring adverse health conditions attributed to perfluoroalkyl and polyfluoroalkyl substances.
Now you've heard the third reading of the bill. The question is, shall the bill pass? Are you ready for that question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have passed S197. We now have up for consideration S196. S196 was read for the first time and referred to the Committee on Judiciary, which considers the same and recommends that the bill ought to pass. Please listen to the second reading of the bill.
S196, an act relating to the types of evidence permitted in weight of the evidence hearings.
Now you've heard the second reading of the bill for the report of the Committee on Judiciary, the Senator from Windham.
President, this bill is currently being handed out to all senators right now, and as you'll see, well, I have good news and I have bad news. The good news is that this bill is, I think, the shortest bill that's come out of Senate Judiciary, at only 2 sentences long. The bad news is I think it's also been, at least so far, the most confusing bill that we've worked on. So I'll do my best in this presentation. So in order to properly explain what this bill does, I'll describe the concept behind holding someone without bail. And after that, I'll also provide a hypothetical example as to how this bill would impact those hearings. So bail is used to ensure that someone appears in court and to mitigate the risk of flight from prosecution. Under Article 40 of our Constitution, all people shall be bailable for their offenses. However, like with most rules, there are exceptions. And in this context, the exceptions allow for a person to be held without bail for certain offenses. Those exceptions apply to people accused of an offense that is punishable by life imprisonment or people accused of a felony that involves an act of violence. These two categories fall under two separate types of pre-trial hearings, generally known as weight of the evidence hearings or hold without bail hearings. Offenses that are punishable by life imprisonment fall under Title 13, VSA 7553, and the violent felonies fall under 7553A, the same title. And the fix that's being proposed here is something that I really consider to be a technical fix that brings some clarity between the different steps of these hearings. So for step one, whenever a hearing occurs under either of these statutes, the first thing that the state must establish is that the evidence of guilt is great, the charged crime. The state can make this showing in either hearing with affidavits or sworn statements. S-196 wouldn't change anything about how the first step of 7553A hearings proceeds, and it would continue to be consistent with 7553. During the first step, the state has to submit to the court that it has substantial admissible evidence as to the elements of the offense sufficient to prevent the grant of a motion for judgment of acquittal at trial. And the same standard applies under Rule 12D of the Rules of Criminal Procedure. And so the problem that we're trying to fix comes with step two. So for the second step for 7553A hearings, S-196 will put that second step on equal footing with 7553 hearings. So once the state has established that the evidence of guilt is great, the state must then establish by clear and convincing evidence that the defendant's release poses the risk to any person and that no condition or combination of conditions can mitigate this risk. And this is where Vermont courts have diverged about whether the rules of evidence apply to this specific step of the 7553A hearing. So S-196 would make it clear that the rules of evidence do not apply to the second stage of the 7553A hearing, and would thus make it consistent with the second stage of a 7553 hearing. So the state still has the additional burden of proving the defendant's risk and that the conditions will not mitigate this risk. And so S-196 would allow the state to make that showing without necessarily having to call the victim to testify. And so again, the problem that we're trying to solve is that some courts believe that the rules of evidence do apply to the second stage and other courts do not. And I also want to repeat that the rules of evidence under current law do not apply to 7553 hearings. So this is not something that's groundbreaking or new or anything like that. And so in the current landscape, a victim in County A may have to come to court during a hold without bail hearing, while a victim in County B would not. And it depends on the judge. So this bill aims to remove this inconsistency and create some geographic equity and also provide clarity to all of the parties. And so I think I'm going to provide a hypothetical example that I think will provide some further clarity, because I know this has been a confusing bill here. So envision two different courtrooms, one in which the rules of evidence are being applied to the second stage, and another in which they are not being applied. If the rules were applied in a hypothetical situation of, let's say, a domestic violence victim who was stabbed and is still, oh, sorry, I left out an important point. These hearings have to happen within 15 days of arraignment. So That's typically around 2 weeks of the assault actually happening. So within that 15-day window, if the rules are being applied, that victim will be required to come in and testify at the pre-trial hearing. They will have to testify at the trial where the rules of evidence are applicable, but this is a pre-trial hearing. In the other courtroom where the rules are not being applied, that victim would not have to testify, and instead their sworn audio statements or affidavits or other evidence that would be admissible at the trial can be used in the weight of the evidence hearing. So I'm hoping that clarifies that we are trying to make different courtrooms on equal footing regarding this rule change. And I will be happy to answer questions if there are any. We did hear from the following witnesses. We heard from a domestic violence prosecutor from the Windham County State's Attorney's Office, we heard from Legislative Counsel, the Defender General's Office, the Deputy Director of the Vermont Network Against Domestic and Sexual Violence, and the Chief Superior Judge. The vote was 5-0-0, and I ask for the Senate support.
You've heard the report of the Committee on Judiciary. The question is, shall the bill be read a third time? Are you ready for that question? Senator from Windsor.
I'd just like to inquire of the reporter.
The Senator from Wyndham is interrogated as the reporter of the bill.
So I just am curious about your witnesses. You didn't hear from the Department of State's Attorneys and Sheriffs?
We did, yes.
Okay. Thank you.
My apologies for leaving that up.
The question is, shall the bill be read a third time? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you've ordered third reading of S 196. We now have up for consideration S 206, which was read for the first time, referred to the Committee on Government Operations, which considered the same and recommends that the bill ought to pass. The bill was then referred to the Committee on Appropriations that also considered the same and recommends that the bill ought to pass. Please listen to the second reading of the bill.
S 206, an act relating to designating Juneteenth as a legal holiday.
Now you've heard the second reading of the bill. For the report of the Committee on Government Operations, the Senator from Windsor.
It is a privilege, and I mean that, a privilege to be able to introduce the Vermont State Senate to S 206. This is the bill that makes Juneteenth, also known as Emancipation Day, Freedom Day, Jubilee Day, and Black Independence Day, and makes it a legal state holiday. As a point of personal privilege as well, I want to thank the Rules Committee and this body for allowing me dispensation to be on Zoom over the last 2 days. And it is very few things that would keep me from my mother's bedside at the moment. And this bill is that important. She's also doing much better. This bill does, so the bill adds Juneteenth, so June 19th, as a legal holiday under 1 VSA section 371A. It numbers it as the 6th recognized holiday, legal holiday in Vermont, and it lists it in chronological order with the other calendar dates. So not an order of priority, but chronological calendar order, and then renumbers the following dates in the subsection. The bill also repeals the section that makes Juneteenth a commemorative holiday. As you can see, it's a type 2-page bill. And while Juneteenth, you may remember, is a federally recognized holiday, it's currently celebrated throughout the state by local municipalities, nonprofits, and community members at large. It has not been given statutory recognition, but will with this change. An important note, while this bill does make Juneteenth a legal state holiday in Vermont, it does not automatically become a paid day off holiday. Not a paid day off holiday by this legislation. Your Committee on Senate Government Operations discussed this point and learned that making Juneteenth a paid holiday for state employees would involve collective bargaining within their union. Your Committee on Senate Government Operations requests the chamber's support on this bill. And since I have the floor, I wanted to take a moment to tell you the history of Juneteenth if you were not familiar with it already. On June 19th, 1865, around 2 months after the Confederate General Robert E. Lee surrendered at Appomattox Courthouse in Virginia, Gordon Granger, who was a Union general, arrived in Galveston, Texas, to inform enslaved African Americans of their freedom and that the Civil War had ended. General Granger announced this and put into effect the Emancipation Proclamation, which had been issued nearly 2.5 years earlier on January 1st, 1863 by President Abraham Lincoln. May I read General Granger's proclamation?
Without objection, you may.
On that day, June 19th, 1865, General Gordon Granger said, "The people of Texas," and this was a crowd of around 250,000 enslaved people. "The people of Texas are informed that in accordance with a proclamation from the Executive of the United States, all slaves are free. This involves an absolute equality of personal rights and rights of property between former masters and slaves, and the connection heretofore existing between them becomes that of employer and hired labor." You can see maybe some issues with that. "The freedmen are advised to remain at their present homes and work for wages. They are informed that they will not be allowed to collect at military posts, and they will be not supported in idleness either there or elsewhere." So historically, even with that statement, we know there was some serious work that had to be done following the proclamation. That's the end of it. We also historically know that the information about the Emancipation Proclamation happening was well known by slave owners long before General Granger arrived in Texas. They kept this information away from enslaved people. We do also know that many enslaved people were aware of the Emancipation Proclamation, but were unable to act on their recognized freedoms because it was not being enforced. So the Union General coming to Galveston, Texas, and proclaiming that changed the dynamic. There's a lot more I could say about the history of Juneteenth and its role in Black culture in America. And the adoption of Juneteenth on the federal level is due in no small part because of the Black Lives Matter movement and the powerful activism done by people of color to reflect how we must overcome further the shameful legacy of slavery and the structural, systemic inequalities built into our nation today due to its legacy. In testimony, we heard an important point raised by our state's executive director on racial equity. She expressed to our committee that while this is a small positive step, we cannot and should not pat ourselves on the back in this moment and not pursue important racial justice work. Furthermore, Vermonters can be proud of our history as a union state, and Vermont being the first state in the nation to abolish the enslavement of persons over the age of 21 in its 1777 Constitution, which proudly signed in Windsor, Vermont, if you did not know. We should remember the value of Juneteenth, and I am proud that we are now going to recognize it potentially as a legal state holiday. In conclusion, I would encourage any Vermonter interested in honoring Juneteenth to consider spending the holiday learning about our history of enslavement and celebrating the Black community amongst us. Concluding, I wanted to use a quote from Bell Hooks, who is a Black feminist scholar and author. She says, "Our freedom is sweet. It will be free. It will be sweeter when we are all free." Thank you to our trustee legislative counsel, Mr. Chernick, and to the senator from Chittenden North for introducing this piece of legislation. Our witness list was our counsel, Mr. Chernick, the executive director of the Office of Racial Equity, Beverly Everest, a concerned citizen, Sean Pratt, a member of the NAACP in Rutland, and the sponsor of the bill. The vote out of committee was 6-0-0.
Bill is then referred to Committee on Appropriations. For the report of the Committee on Appropriations, the Senator from Caledonia.
Thank you, Mr. President. The Committee on Appropriations reviewed the bill, and as the reporter of the bill indicated, it was the question was whether the making this holiday a legal holiday would have implications relative to compensation and therefore add additional spending. That is not the case, as was confirmed. This is a benefit that would have to be negotiated through collective bargaining. We have other holidays, Indigenous People Days, for example, that have been the subject of bargaining. And so once that was confirmed, the committee's vote was 601 in favor of the bill. Thank you.
Now, you've heard the reports of the Committee on Government Operations and the Committee on Appropriations. The question is, shall the bill be read a third time? Are you ready for the question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay. The ayes have it, and you have ordered third reading of S-206. That now, my understanding is we will be passing over S-150, which will bring us up to H-659. 659 was read for the first time, referred to Committee on Finance, which considered the same and recommends that when amended, the bill ought to pass. Please listen to the second reading of the bill.
H-659, an act relating to captive insurance.
Now you've heard the second reading of the bill for the report of the Committee on Finance, Senator from Washington.
Thank you, Mr. President. The bad news is that this bill is almost 200 pages long and that it includes two of the most sleep-inducing subjects that we deal with every year. And I'm presenting it to you 10 minutes before lunchtime. The good news is I talk very fast. There were no changes to these bills, and there are two bills encouraged in here. The first bill came over to us very early from the House, and that was the captive insurance bill. It's a general adjustment that we make every year. And then we learned that the annual CFR housekeeping bill had not made it over here in time to get a bill number. And so finance was asked to attach that to the captive insurance bill. And that's what we've done, and thus the weight of the bill. The good news is I talk very quickly and I can talk faster. And if you trust me, there are several model laws in here. I can ask you to trust that these are model laws and approved and go through them in very little detail, or I can read you these 7 or 8 page summaries of each one of them. The first section, section 1 through 18 is captive insurance. First section is sponsored captive insurance agencies. These are your vanilla flavored, your standard captive insurance. You get a group of similarly situated businesses. Generally, I'll use a religiously affiliated hospital because that was one that came to us. These similar hospitals are all over the country. They decide a captive would be a good way to give them some extended insurance coverage. So each one has to join. That's a participant. Each of those participants' assets and liabilities are put into a separate box called the protected cell. Think of this as an apartment building. Each cell is an apartment. And as we play with this, we find out we sublet some of those apartments. Right now, with the commissioner's approval, these sponsored captives can take in some unaffiliated cells. But the commissioner, the department feels that that law is a little too wide open. If you're a hospital, you can't decide to take in your brother-in-law's chain of clothing stores. It has to be a controlled, unaffiliated entry. And this would make that correction and give a definition. A controlled, unaffiliated might be an ambulance service that the hospital depends on. Maybe there's several local ambulance services. They could take them under, or with laboratories that does all the state, but they have to have some control, some relevance. Section 2. Okay. Yes, this would allow existing forms other than sponsored, agency captives, association captives, industrial insured captives to become cells within a sponsored captive with all the other things that we just did up top. Section 3 has to do with parametric contracts. We did this last year. A parametric contract, what we said last year is a parametric contract is not an insurance tool. It is a contract. These are the kinds of contracts business can sign that says, if there is an earthquake in California, then your theme park in California gets paid X. Well, the department has found out since then that many of these contracts are set up as insurance products. If there's a contract and you have damage, we cover the damage. And so this removes our definition of parametric contracts. The section 4 reduces the amount of money set aside proposals for agency captive insurance companies in a reinsurance control. These are agencies are owned by insurance agencies or brokerage firms. Experience says they don't need to have 500,000, they only need to have 250,000 on reserve. Section 5, yes, that takes the captive insurance regulatory and supervision fund. Last year, we allowed the captives can retain portions of the premium fund. DFR is a major funder of the general fund. We allow them to keep certain percentages of the funds. Last year, we went up from 11 to 13% that could be placed in the insurance regulatory and supervision fund. We missed some spots, and this just makes everything the same. Section 6 makes it clear under present law, the commissioner must approve if reinsurance is written by an alien captive and requires the permission of the commissioner. In insurance speak, a foreign captive is New Hampshire, an alien captive is anything outside the borders of the United States, not from outer space. They feel now that they have adequate supervision and rules to deal with this, and it doesn't need the commissioner's approval, so that is returned. Section 7 through 18, good portion of this bill, all deals with confidentiality. Right now, over the years, many sections have done definitions of confidentiality. They may or may not all conform. What this does is remove all those departmental definitions and instead references them to the department-wide. The captive insurance has a department-wide standard of confidentiality. Also makes it easier to update when you only have to do one. That is the end of the captive section. Sections 19 through 23 are housekeeping. 19 allows the commissioner, and this is now DFR commissioner, to impose an enhanced civil penalties for securities laws that violate law violations that involve a vulnerable adult. Section 20 changes, changes the name of the Vermont Financial Services Education Victim Restitution and Whistleblower Award Fund to something simpler, Vermont Financial System Representation, Education, and Victim Restitution Fund. And it allows right now, a portion of any security settlement goes in there. This would allow a portion of any other settlements in any other section, banking, insurance, to be played in there. Yes, section 21 through 23, it deals with insurance cancellation and non-payment. This is not what we've dealt with in here before, allowing you to get an email saying your insurance is canceled. What this says is it can be sent to first-class mail as long as there is an approved tracking system so that it can be verified at whether or not it was delivered. Sections 24 through 27, this is one you can trust me on. This is an NAIC, National Association of Insurance Commissioners model bill. It will be required probably by January of 2026 as a requirement for accreditation. And you want to have accreditation. Basically, it gives the commissioner of the department more tools to be able to assess the financial viability of a holding company, and it sets up a process for receivership in case that holding company gets into trouble. Section 28, which is the one I bet I will get questions on, is pet insurance. Over the last couple of years, there are several forms of non-traditional insurance that have become widespread. Last year, we formalized travel insurance. It's come a long way since you put a quarter or a dollar in a machine at the airport. I think you survived or got $25,000 or something if the plane crashed. So we did that. This one, we're doing pet insurance. It basically sets up things that insurance companies can or cannot do. Right now, pets are covered under property and casualty insurance, which is a little broad. This says that pre-existing conditions can be excluded, but all of this has to be disclosed to the consumer. But that if you get an insurance policy and your dog's fine, but in the term of that policy, your dog develops cancer, cancer cannot be excluded from treatment when you renew the policy. It wasn't a pre-existing condition. It requires disclosures, says you can have a waiting period, but it can be waived after a physical exam. It makes clear that the sale of wellness programs, which I'm not familiar with, but apparently you can buy a wellness program for your pet. That is not health insurance, that is not pet insurance, and that it cannot be marketed as such. And it requires that the producers, those selling them this insurance, need to have some training before they're allowed to sell it. Sections 29 through 49, again, is Money Transmission Modernization Act. And this is the one, unless you want me to read, I think I have 6. It comes from NAIC on the insurance side. Basically, money transfers are anybody that takes money from one place and moves it to another. PayPal. I make a payment on PayPal. They charge it to my charge account and send the money to whoever I bought something. Venmo, it takes money, moves it around. But the really new one is online. All kinds of. What this does is Vermont's just adopting it. All these sections, we pretty much do all of it. It just sets up general requirements. This will be a national standard. We will be in line, make sure everybody has the same terms for the same activity. Qualifying licenses, all the rest of it. The one place that we didn't adopt is, yes, it is the whole section on virtual currency. And that is not required. It would be a good thing if you adopted it. Vermont has been regulating virtual currency, the machines where you can purchase or send virtual currency. We've been regulating those for about 6 years. And so what this bill does is just take the recommendations and kind of blend them in with what Vermont's already doing so that we are there on that national standard. And I believe that is it. We heard from Sandy Bigglestone, who's Commissioner, Director, Deputy Commissioner of Captive Insurance, Christine Brown, who is Director of the Captive Insurance at DFR, Emily Brown, who's the Deputy Commissioner of Insurance at DFR, Aaron Frenick, who's the Interim Deputy Commissioner of Banking, Emily Kasicki, Director of Policy at DFR, Maria Royal, our Legislative Counsel, and the vote was 601. We ask this body to concur.
So the question is, shall the bill be amended as offered by the Committee on Finance? Are you ready for the question? If so, all those in favor, please indicate by saying aye. Those opposed indicate by saying nay. The ayes have it, and you have amended the bill as offered by the Committee on Finance. The question now is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please indicate by saying aye. Those opposed indicate by saying nay. The ayes have it, and you've ordered third reading of H 659. That completes the orders of the day. Senator from Chittenden Central.
Thank you, Mr. President. Pending announcements, I would move that the Senate stand in adjournment until 9:30 a.m. Tuesday, March 9th.
Are there any announcements? Senator from Washington.
Thank you, Mr. President. Senate Finance will meet at 1 o'clock.
Senator from Addison.
Mr. President, Senate GovOps will meet at 1:15. Thank you.
Senator from Bennington.
Thank you, Mr. President. Senate Education will meet at 1 o'clock.
Any further announcements? Wow. Seeing none, the senator from Chittenden Central has moved that Senate now stand adjournment until Tuesday, March 19th at 9:30 a.m. Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes appear to have it. The ayes have it once again. And the Senate will stand adjournment until Tuesday, the 19th at 9:30 a.m.